We got a good episode today. This is an important episode that everyone should know about because everyone deals with these. And we're talking about contracts. And contracts, very important in our economy. But a lot of people don't really understand the basic principles, importance of contracts, why we have them, why they work. And so, this is an important episode. I'm going to try and break down a little bit on what they teach about in law school and contracts, but also just practical matters for everyone to know what they should know about contracts. So, just so you know, there are different types of contracts. So you can have a written contract that is signed by both parties, but you can also there's also different types of contracts. You can have a verbal contract, so just verbally speaking back and forth can create a contract. And you can also create a contract where you do have something in writing, but it's not necessarily signed by both sides. And in a lot of circumstances, that can still be enforceable. So just saying, well, I didn't sign the contract, sometimes might not work, and there could still be a contract. The biggest thing that I always tell clients about contracts is, in order to have a contract, so one question and what you look at in law school and what you learn about is there even a contract? Has a contract even formed? And so the big thing is this legal term called consideration, or also another term is mutuality, or also another term is just exchange of promises. So every contract has to have some kind of exchange in promises. So, for example, if somebody told me to run a mile, and they say they would give me a penny if I ran a mile. Technically, that could be considered a contract because there's an exchange in promises. So saying, hey, I run the mile, so I'm doing something, so I'm part of the contract, and then the other person, they're giving me a penny, and so there could technically be a contract there. There's an exchange of promises. One person is the giver of the penny, that's what they're doing. The other person is running the mile, so two actions that they're going to do. So if they just said, so if it was a little bit different and they just said, hey, run a mile, and there's no promise of a penny or anything, and that person doesn't do anything, and I run a mile and I say, hey, give me a penny, there's no consideration there because they didn't promise to do anything on there. So that's an important part of contracts. And the reason why so the whole purpose of a contract is you have two sides agreeing to do something on behalf of on both ends. So if you have something where somebody just agrees to do something, but the other side doesn't agree to do anything else in exchange, then you may not have a contract. So if it's just, somebody writes up this fancy contract with a lot of legalese, but really in simple terms, it just says, I have to go run a mile, but that person doesn't, but there's nothing in exchange for me running a mile, then there's not a contract. So I see that issue. I do a lot of employment law, so I see a lot of those issues arise when I look at non-compete agreements that employers have employees sign. So the non-compete agreement can just say, you are not supposed to compete for this amount of time, have the non-compete language, but then there's nothing in exchange on the other end. So there has to be something for that person, for that to be a contract. So if you have a non-compete agreement and the employer doesn't agree to do anything on their end to pay them to not compete for that amount of time, then you may not have a contract. I do see a lot of employment agreements that say in exchange of your salary and wages, and that's a harder one. I mean, on one end, you could argue that, hey, that isn't part of the agreement. This is something in addition to salary and wages. You're not agreeing to salary and wages for non-compete. You need something in addition to sitting on the sideline for a year, 2 years, however long your state allows. So that's a tougher one, but I see a lot of those too. But that could be an issue as well if it just, I mean, depends on the judge though, if they think that is enough for consideration or not enough for consideration. And then also, I mean, the whole purpose of a contract is, again, that exchange of promises, two people promising to do, or two parties or whatever, promising to do something on behalf, in exchange for something else. And so the importance of contracts on the legal end and what attorneys are trying to do when they draft contracts is they want to memorialize what the parties have agreed to. That's one thing they do with the contract. So they want to make sure that the terms are clear and everyone understands what they're supposed to do, what the role is, how long the contract's supposed to be. So the biggest things, the most material terms in the contracts are usually how long it's supposed to be. So like a year, 2 years, 3 years. And then also typically the amount, the price, $400, and then whatever it is, an exchange of services or goods. Those are the main material terms. So what is everything else that's in the contract? And one thing I always tell people too is that what attorneys are supposed to do is they're supposed to prepare. They're supposed to prepare for worst case scenario. I always say Armageddon. You're supposed to prepare for Armageddon. So an attorney is supposed to think of, okay, what's the worst case scenario that could happen in this contract? And then you create terms on how to mitigate those circumstances. So something may not ever happen, but in case it does happen, you have language that you can go to say, okay, well, we're supposed to do this, instead of nobody knows what they're supposed to do. It gets caught up in court. And so you think a lot. So you have to think a lot too outside the box as an attorney on, okay, what happens if this happens? What happens if this happens? And so contracts are also like an insurance policy too, in case something goes wrong. And that's why they're so important as well, is, okay, you did this wrong. I can look at this. This is what we need to do. And if you don't have that, then it's like, okay, what are we going to do here? And also they're negotiated instruments. And again, it's memorializing what the parties have negotiated. And so in today's age, there's a lot of people that are going to ChatGPT or just find contracts online. And the big issue I have is a lot of people think that a contract is just kind of like, just this thing that you have to check the box off for to have, saying like, oh, we just need a contract. We just need some words saying things, that there's something in here. And so, yeah, we have a contract. We're good. Check that off. But it's more complicated than that. So the problem is getting contracts online, and also going to ChatGPT is ChatGPT doesn't know the scenario. It doesn't know the specific terms. ChatGPT doesn't know what kind of terms should be in, doesn't know what you guys have talked about, doesn't know what you need to be protected. And so when you come up with contracts from ChatGPT or online, it really isn't doing you any favors. And then also, I mean, both sides want to draft contracts favorable for them and their scenario. And so when I look at employment contracts and those kind of situations, they're really not as employee friendly. And a lot of employees don't have the leverage to negotiate the terms of their contract, especially lower end employees. I mean, if they try and negotiate, they just might, especially if you're in at-will state, they might just say, "Hey, well, we're not going to change the terms. We're not going to hire you. Something, take it or leave it, kind of thing." And so there's a lot of contracts that are drafted in favor of one party. So employers, they have attorneys that draft their employment contracts if they're smart employers and don't pull them offline. And so it is crafted for them in their best interest, in their best scenario. And that's one thing you need to know too, is that just because a contract has been drafted by an attorney doesn't mean that it's still a good contract for you. It may be in favor of the other person. And so that's why it's important to get an attorney to review the contract and try and draft and negotiate terms that are more favorable to you. And that's the big thing on pulling offline online is, you're not doing yourself a favor if you don't have someone that knows how to draft a contract in your favor. So you could pull a ChatGPT contract or a contract online, and it's not going to be favorable to you. You're not going to have an attorney that's going to beef it up for you, that's going to protect you. I mean, there's horror stories I had. I remember one of my friend's brothers. He got into an investment with somebody for property, and the contract had terms that, like, he was the one giving the money to this investor. And typically when you're the investor, you hold the power, and terms should be favorable to you. Like, you want an interest rate, you want some kind of lien or collateral. You want some kind of guarantee. You want something, if you don't see your money, you have a way to try and recoup that money. And you also want, if you have to sue, that you can recover your attorney fees. So if you don't have that, you may not be able to recover your attorney fees. So also in your contracts, you want to make sure that you have an attorney fee provision depending on your circumstances. So you don't have to pay an attorney and then not be able to recover your attorney fees. And so you have to foot the whole bill, which could be more expensive in having to pursue a breach of contract case. And unfortunately, sometimes those contracts can go awry. And so if you don't have those kind of provisions like a lien or an interest rate, if they fail to pay, then you can't recover that type of remedy. So that's, again, thinking Armageddon and thinking and drafting in favor of someone. So, I mean, I would say that if you are going to sign an agreement that is a pretty serious agreement, so I help franchises too. I review lots of franchise agreements. Those are ginormous documents. Franchise agreements are usually 30 to 40 pages long. And then also there's a franchise disclosure document that's almost as long, if not longer. And many people buy a franchise without even speaking to an attorney. And that is, I'd say, big no-no, is that kind of scenario. You want to look at it with an attorney. It's worth it. And again, it's like an insurance policy. The attorney can take a look at the contract and the scenario and say, hey, I think that this is you need to look out for this, look at the red flags, or you need to be aware of this. And then also helping them understand terms that could possibly be negotiated and help negotiate certain terms that can be more favorable to you. So it's if you're entering into a contract that is pretty significant, and I guess the question is, I guess there's not a defined line on when it gets to the significant point. But I mean, if you got a contract that's, $10,000 or more, it may be good to have an attorney look at that. I mean, if it's a lower contract for $100, $200, $300, $400, maybe it's not as important. If it's a service contract that's, goes on for quite a while, $500, $600 a month, that could be important to take a look at. Leases can be important to take a look at, especially commercial leases. Yeah, I mean, anything that you're going to invest a lot of money in, you want to have an attorney take a look at it. Because, yes, I've had lots of people come back to me who either they're investing in something, they're buying a company, or getting a loan or something, and they come back, they didn't have an attorney review it, and then they come to me and say, oh, well, can you review this now? And if they do that, I mean, my hands are tied. There's only so much I can do. If you've signed that agreement, you're essentially bound by the terms. So what can I mean, it's a lot harder for me to help them find a way out if they want a way out, or a way to change terms. If they want to change terms, it's a huge uphill battle. So you want to make sure you have an attorney review before you sign instead of after. So yeah, that's a big deal, and important thing. And so getting into a contract, so you need that mutuality consideration. You also have to have both people agree. You need an acceptance. Both people have to accept the contract. So either verbally, so if I say, if you mow my lawn, I'll give you $30, and you say yes, then there's a contract. But if I say, if you mow my lawn, I'll give you $30, and they don't say anything, there may not be a contract. I mean, and if that person later comes a couple days or weeks or months later and mows my lawn and demands $30, then that could be a legal issue on, well, was there acceptance? Like, I made an offer, so that's part of a contract. There has to be an offer made, and there has to be an acceptance on that offer. And there's certain things on, if the offer is extended, how long does it take to accept? And so, I mean, maybe a couple days, if they came a couple days, maybe there could be a claim that there was an acceptance. But also, if he came a couple weeks or a couple months afterwards, it'd probably be harder to claim that there could have been acceptance with how much time there was after the offer was made. So also you have to show that there's a contract, that the person actually accepted it. And that's why putting things in writing is so important too, because obviously you can see whether or not it's accepted because the terms are spelled out and both people have signed it. So that's why it's good to get things in writing as well, and making sure that there's no hiccups down the road, because if you do have a verbal agreement, it could be harder to prove what the terms of the agreement were down the road. And we're humans, we don't have amazing memories, and so some people might say the terms are slightly different than the other terms. And then you're just going to have to give it to a judge, and the judge has to weigh the credibility of both sides, and you have to pay for an attorney to get that worked out. And so, yeah, it's good to make sure that you do have things in writing. Sometimes people sometimes it seems like a turnoff to people on, hey, wait a minute, you're throwing this 4 or 5 page document at me. What's going on here? Like, I thought we were friends or whatever. But I mean, it's just the nature of the beast. And it's, again, an assurance policy. Even though you guys may be friends or may have a good business relationship, you want to make sure that what you guys talked about, especially if it's a more serious deal, is memorialized in writing. So, so making sure that there's an acceptance. I mean, and also too, I mean, how it's accepted, somebody doesn't necessarily have to say verbally, I accept, or necessarily have to sign the contract. There could be a contract by the actions of the party. So again, even though the person who I offered to mow the lawn for $30 didn't say I accept, but later came and mowed the lawn that day, could be acceptance just by his performance, saying that, yes, I accept the terms and I'm performing. So if he did it that very day, and if I tried to claim, well, he never accepted, I'm not going to pay this $30, it would be hard for me, most likely, to say, we never accepted. I never accepted this, even though you mowed my lawn, I'm not going to pay you $30. The other thing too is, if you memorialize something in writing and you have a contract, and that person doesn't sign the contract but then mows the lawn, then that could be harder for the lawnmower to say that there's an acceptance if there was an actual contract drafted for him to sign and he never signed it. Then you could say, hey, then that's evidence on the other and say, well, there wasn't acceptance because the only way to accept was him signing it. It wasn't a verbal, it was supposed to be a written contract. So that's another thing, as far as acceptance, how that works. And again, why it's important to get everything memorialized in writing. And also the other thing too is, even if both parties don't sign the contract can still be enforceable, and it depends on who signs the contract and who's trying to enforce the contract. So if, going back to the lawnmower situation, if I sign the contract for $30 to mow the lawn, and I sign it, but the lawnmower doesn't, and say the lawnmower just doesn't mow my lawn, and I try and enforce that contract against him, saying, hey, we had a contract, it would be hard for me to enforce the contract because he never signed the contract. So how can I enforce that against him? But if the lawnmower, if I sign the contract and the lawnmower guy doesn't, and he mows my lawn, and I don't pay him $30, he can enforce the contract against me still, even though he didn't sign it. Because I signed it, I'm bound by the terms, and he can enforce it against me. So also, even if one person signs it, depending on who's trying to enforce it, if you're trying to enforce it against the other party and they signed it, then you can still enforce it even though you don't have both signatures. And the other thing too is, why it's important to get contracts in writing is, again, with that ambiguity on who said what. An important part of a contract is an integration clause, and most attorneys put in an integration clause and what the purpose of that integration clause is. So this is kind of like the boilerplate language, but all that boilerplate language still serves a purpose. So an integration clause means that this is the entire agreement. There is nothing outside this agreement. So if you have an integration clause, then if somebody tries to enforce a contract and say, hey, wait a minute, we also talked about this before we signed, then that can't come in at court because of the integration clause. So they're bound by the integration clause. So it's also good because it provides continuity and finality. But if you create a contract and you get it offline, ChatGPT, and you don't have an integration clause, then the other party could say, hey, well, we talked about this, and they could sue you for it, and they could still enforce those terms that aren't in the contract because you didn't have an integration clause. So again, that's why it's important to have an attorney review contracts. And then also, when it comes to the formation of contract, you have to have the mindset to accept contracts. So if you're under 18 years old, you can technically enter into contracts per se, but the 18, if you're under 18, that teenager can decide whether or not they want to continue to have that contract or not. So if you enter a contract with a 16-year-old, and if I enter a contract with a 16-year-old to mow my lawn for $30, and we both sign it, and he doesn't show up and doesn't mow my lawn, then and I try and enforce the contract against the 16-year-old, the 16-year-old could say, "Well, I don't want it to be a contract anymore," and that they can do that. And so that's a tricky thing too, is entering in contracts, and the purpose and basis because of that is just they don't have the same type of mindset as adults do, know the seriousness of what they're getting into, and so because of that, they say that have the mindset to get into that contract. And so yeah, you have to have that mindset, and that leads to other scenarios too. So like, for example, say I'm in a situation where this guy kidnaps me and ties my hands, puts a gun to my head, and says, "Sign your house away to me," and I do, in fear of my life, sign my house away to him. But that's also another mindset scenario where I could claim that I was under duress and there wasn't a contract. And so if I wanted to go after him in court and he took my house and I want my house back, I would have a very good argument saying, well, there was no contract because you put a gun to my head. And so I was not in the mindset. So there's duress. If you're under duress and you accept, you could have a defense saying, hey, well, there wasn't a contract. Also, there's other scenarios where, if I want to buy a house and a guy says, I'll throw in I'll throw in $200,000 as well, or whatever, or other kind of deals saying, well, this house is completely bulletproof or something, completely fireproof, like no flame can light it on fire, and I rely on that representation, and the representation is false, so fraud. So if somebody says something false and I rely on that in entering into the contract, and it's material, so it can't just be something, nitpicky, like, oh, all the doors are gray and they end up being white, that may not be material. So it has to be a material term, but if it is a serious material term to me, then I could get out of the contract and say, well, I was fraudulently induced into entering into contract. So that's a way to show that there wasn't acceptance too, because I thought the terms were this, and it was actually this, or I thought the scenario was this and it's actually this. So you can also get out of the contract because of fraud. And then also, we talk about mental capacity too. There can be scenarios where someone may not be mentally competent, may have some kind of mental scenario where they just didn't have the mental capacity to enter into a contract. So that's why a lot of people have guardians, where they can enter agreements for them. So maybe older people with Alzheimer's, people with dementia, they enter into contracts, they sign their house away. Somebody could come and say, hey, wait, this isn't a valid agreement because this person didn't have the mental capacity to enter into the agreement. So that's a big thing too on acceptance and formation of a contract. And so the other thing too with a contract, so question is, if I breach a contract, then what are the ramifications? What are the damages for both sides? So so under a contract, the damages aren't like a personal injury case, but a lot of people may think they are, but they're not. So their damages are a lot limited. So personal injury, you can get like pain and suffering, you can get punitive damages. That really isn't on the table in a contract, and really it's just what you expected to get out of the contract, and then also maybe some incidental charges that you incurred because somebody breached the contract. So, so the guy was supposed to mow my lawn, and he didn't show up, and he didn't mow my lawn, and so I could potentially go after him for $30. If we agreed to $30, I could say, you owe me $30. You're supposed to mow my lawn. You didn't. If something, if you have something that's foreseeable that damages you. So if I was supposed to, I don't know, hold a wedding, and the lawnmower knew I was holding a wedding event, and my lawn was knee high for whatever reason, and it needed to be cut so people could walk on the lawn, and it wasn't, and so I couldn't hold the wedding event. Potentially I might be able to recover damages in having to fix the lawn scenario if it's a foreseeable. If the lawnmower had no idea about the wedding event, maybe harder for me to prove that it was foreseeable. But if they knew about the wedding event, then I could say that yes, that's a foreseeable damage. So some out-of-pocket expenses that I incurred because of it. Or also like car rental. If I got a car rental agreement with somebody to rent a car for 5 days, and we agreed to $50 a day for the car rental, and then the car renter guy backs out and says, hey, I'm not going to do this, then if I have to find another car and the car rental is $75 a day, then the question is, okay, well, what are my damages? Because I did get a car. I had to pay $25 more. So do I get the $50 or do I get $75? And the law says I get $25. I get the difference. So I should have gotten a car for $50. Instead, I had to pay $75. So I should have gotten the benefit of the bargain. I should have gotten a $50 car. So my damages are $25 a day, or $125 for 5 days. So that's how damages work. So also, if you do have a breach of contract, maybe say you have $100 agreement with somebody to mow your lawn or something, and they don't do it, and you say, aha, I have a breach of contract, I have a legal claim against you. One thing to consider is, what's the worth to go and pursue remedies in the breach of contract? Is it worth it to get an attorney to defend you? If you don't have an attorney fee clause in it, probably not. It's probably not worth it to get an attorney in that scenario. If you want to try and pursue the case by yourself, if you want to go to small claims court, is it worth it? You're going to have to pay a $100 filing fee. So if you had to pay a $100 filing fee in small claims, and then damages is $100, then it may not be worth it to go after them for that. So one thing to think about too in pursuing a breach of contract claim is you have to think of cost benefit analysis. Is it worth it to pursue this, or am I going to be out? Am I going to spend more money having an attorney try and work this out with me? And then also, what's my likelihood of prevailing? Can I actually prevail? Can I actually win? Do they have good defenses? So that's one thing to think about in a breach of contract case. So just because you have a legal claim, like somebody did you wrong, also you have to look at the cost benefit analysis on, is it worth it to pursue it? And that's one thing, just, from a practical standpoint. A lot of people don't like when they get done wrong. and they want vengeance. And I've had clients like that. But in the end, they always regret it. And sometimes it's worth it to just cut your losses instead of pursue a claim. Because, I mean, if you have a legal claim, it's always on the back of your mind. You're always thinking about it. It kind of stresses you out. And you're having to pay an attorney for it. You don't know how it's going to end up. And if for whatever reason you lose, then that hurts. And you end up with all these legal fees and you don't get what you have. And so, yeah, there's a lot of buyer's remorse. So sometimes it's best to just look at the scenario, and even though it stinks, maybe someone did you wrong, the best option in a lot of scenarios is just to walk away and just cut your losses and move on, essentially. And that doesn't apply. That applies to all cases that are out there. That just doesn't apply to a breach of contract. That applies to all legal cases out there. Like, is it really worth it to pursue this, and what's the cost benefit in pursuing it? So, yeah. And another thing is talking about, so kind of going back to contracts and whether or not there's an exchange of promises. We live in a world now where you can agree to 30 pages of a contract by just clicking a yes button on the internet. I'm not a fan of that at all. I mean, I guess judges say that I guess the general consensus in the United States is if they had the chance to read it, if they wanted to, then they're bound to it, even though they didn't actually see it. So if you give them the link and say, oh, yes, I read the privacy policies, even though you didn't read the privacy policies, then that's your problem then. But privacy policies in the internet are interesting because one question is there consideration in privacy policies? Usually how privacy policies work is what the exchange of promises is if you want to use our website and the functions of our website, then in order to do it, you have to agree to this. So I guess technically maybe there's an exchange of promises there. One person using the website, one person offering the website. So kind of like a service per se. But I guess kind of on a side note with privacy policies, I've helped clients deal with privacy policies in Europe, and what's funny is Europe is on a completely different level than the United States, and the United States is like a third world country when it comes to privacy policies. And Europe is very protective of people's private data. And they kind of have like importer-exporter laws on exporting data out of Europe, and requirements of being compliant with the Europe standards in order to export that data. And there's hefty fines that people can face if they're not compliant with the European standards, like $200,000 per or euros per violation. And also they're more keen on being very clear on disclosing on what privacy is, what data is being collected and how it's being collected, and disclosing that to the user, and then also how long that data can be collected and when that data has to be deleted, and also certain things that a person specifically has to say yes to. So instead of just clicking a button saying, yes, I agree, you have to click something saying like, yes, I agree specifically to this type of data. Yes, I specifically agree to this type of data. So that's why with a lot of websites, when you see those cookie things pull up, that's usually because it's probably a website that's trying to comply with European standards. In the United States, it's not like that, and really it's more vague, and really a lot of people are in the dark on what kind of data is being collected and used, and how long it's being used, and where it's going, and what third parties it's going to. Uh, so that's kind of an interesting scenario in the contract world. And again, I mean, I think it's good to have transparency. I think United States is more pro company, pro corporation, and they can see the benefit. Corporations making big money off people's data, so I think they're not as hard as European, where they're more focused on the individual and individual rights in that scenario. Uh, yeah, so that's really the big picture when it comes to contracts, things you need to know when it comes to contracts one-on-one. So yeah, next time you have a contract, it's a big deal, it'd probably be good to reach out to an attorney to review it. And yeah, I'm an attorney, so I'm the weird guy whenever I go to some play park or facility or something, and they give you this waiver. I read the entire language of the waiver, and also when I bought a house, I read the entire uh, agreement for my mortgage. And I mean, it was the most important document probably in my life that I signed, and so I wanted to review what those terms were. And I mean, I guess I kind of felt like being made fun of to read it, because the title person is supposed to give you a legal breakdown of the terms, but it's just like, well, why? Like, I'd rather read it. I'm an attorney. I don't need someone interpreting it for myself and want to know all the terms about it, prepayment, how to make prepayment, stuff like that. So yeah, and yeah, with those waivers, I mean, there could be scenarios too where there may not be consideration with waivers as well. So you're waiving your right to any personal injury claims that you may have against, if it's a trampoline park, against trampoline park. But also, just so you know, even though those waivers exist, there are probably some terms in there that you can't waive. And if you get hurt and you sue them and they say, well, you signed this waiver, you still might be able to say, hey, well, this isn't enforceable. You can't waive something like this. So there are some terms in contracts, even though there's a term in there, it may violate law. It may violate public policy. It may violate state law. For example, if somebody gives me a loan and the loan is 5,000% interest, that is probably illegal. Uh, so yeah, so there are some terms in there too that maybe you agreed to them, but also there could be some things out there where they may not be enforceable and they violate state law. And so that's why in most contracts there's what's called a severability clause too, which is boilerplate language. But essentially what a severability clause does is it says if there's any part in this contract that says it's unenforceable, everything else in the contract will still be enforceable. So if you don't have that, and somebody tries to get out of the contract, then a judge could say that, yeah, the whole contract isn't enforceable because this part is illegal. But if you have something in there, a severability clause, and the judge says, okay, paragraph 2 is illegal, but there's a severability clause, so everything else is legal. So you can try and essentially salvage the contract if there's parts that are legal. So that can be beneficial too, to have a severability clause, I guess, depending on what side you're on. And then also another big thing is that's always in the boilerplate is choice of forum. Where do you have to litigate if there's a breach of contract? So if I sign a contract and it says I have to litigate in Florida and I live on the West Coast, and then the person in Florida breaches the contract, now I have to spend a bunch of money enforcing the contract in Florida. I have to get a Florida attorney. I may have to fly to Florida myself for some hearings, whatnot. And so it's more expensive for me. So that's one thing to look out too. If you're signing a big contract, you want to look at that forum selection clause, because that could affect you down the road and may make it harder for you to have to enforce a contract. So you definitely want a contract where the forum is favorable to where you are. And so that's again why it's important to have an attorney review that, because there's just may things that you may not catch, may not understand, and just may not understand the legalese of a contract. So yeah, so that's pretty much it in contracts. Thanks for listening, and we'll talk to you next time.